Chapter 7 involves preparing about a petition that's going to be about 60 pages long. It probably has about 500 questions. So we're going to spend several weeks and several meetings in my office working, and it can get very tedious to put this thing together. All right, then once it's filed, within about 24 hours or so, a bankruptcy trustee is appointed. And in theory, and I emphasis the theory part, in theory, this bankruptcy trustee owns all of my client's assets, all the way down to their socks. Well, what happens is I will have claimed, as part of that petition, we will have claimed as much of the assets that this person or this family, this couple has as possible. Most of the time, in most of my cases, I manage to claim all of the assets as exempt, all right? Once they're claimed as exempt, unless the trustee files an objection to the claim of exemption, after a period of certain time, those assets are deemed to have been abandoned by the trustee and ownership goes back to my client. All right? So if you had your house for sale or something like that, and you were thinking in terms of filing a bankruptcy and then trying to complete the sale, that would be a very bad idea, because at least technically speaking, during a great deal of the time that the bankruptcy is pending, you don't own your house. Not really, it belongs to the trustee. So if we manage to claim everything as exempt, my clients get to keep all their assets. If we manage to claim almost everything exempt, they get to keep the things we manage to claim as exempt, but the things we can't claim as exempt, they may lose that. The most common situation where we may not have all the assets claimed as exempt is where we are using the state exemption statute to claim the assets as exempt. Well, you see, we have state exemptions that we can use, or we have federal exemptions that we can use. The trouble with the federal exemptions is that they do not have a very good homestead exemption. And the trouble with the state exemptions is that they have a good homestead exemption, but the rest of the exemptions have a lot of gaps. So it's not unusual in a state exemption case for my clients to lose or to have assets that are not exempt. The list would look something like this. The upcoming tax refund would not be exempt. 75% of the paycheck coming in after we file the case is not exempt. Most of the money in a bank account would not be exempt. And then things like snowmobiles, boats, maybe a motorcycle, guns, and some jewelry may not be exempt, as well as other things. Could be a stamp collection, a coin collection, that sort of thing. And it's quite common that if we have to use the state exemptions, then we're going to have $5,000 or $6,000 in a typical case that's going to have to be paid to the trustee if my client wants to keep these non-exempt assets. Now, the trustee can just take the non-exempt assets. Most of the time, the trustee doesn't want those assets. The trustee wants a check. You come up with the asset, you come up with the money somehow and pay off the trustee, then you can keep whatever it is. So once we get past the issue of are all the assets exempt, and is the trustee going to walk away from your assets, then the next thing we want to see is the bankruptcy discharge. Now, about a month after we file, there's going to be, I call it the hearing. The technical term is the meeting of creditors. And at the meeting of creditors, if there's any kind of a problem with the case, usually it gets discussed at that time. At the meeting of creditors, my client is going to be put under oath and is going to be questioned. If that goes well, then 60 days after that hearing, or meeting of creditors, as the technical term for it is, the meeting of creditors, 60 days after that, or about 60 days after that, the court issues in a court order called a bankruptcy discharge. Now, the discharge is a piece of paper that says that for the most part the debts are gone. What the discharge means is that all of the dischargeable debts are discharged. Now, most debts are dischargeable. Credit card debts are dischargeable, for example. Medical bills are dischargeable. When it comes to things like child support and spousal maintenance, things that are ordered by a family court in a divorce case, those are usually not dischargeable. Another thing that almost always can't be discharged is student loans. And then when it comes to taxes, sometimes we can get the taxes discharged, sometimes we can't. If it's a sales tax or a withholding tax that you're supposed to have paid because you were running a business or you had employees, it would almost never be dischargeable. If it's an income tax, it might be dischargeable, provided that we meet several if, buts, and maybes. The most significant one to me of which is it has to be at least 3 years since you filed the tax return. And there's another whole list of other ifs, buts, and maybes about getting the taxes discharged. I usually tell my clients, we'll know for sure the taxes were discharged if the IRS or if the Department of Revenue starts treating it as if it's discharged and quits trying to collect it. So as a practical matter, I've talked about, in earlier videos, I've talked about making a pile of the bills and doing an incantation and making them go away. It's not quite that simple, although for credit card, for many of the debts, it may kind of seem that way. Once we get the discharge, most of those debts are gone. It will only be a very small number of your debts, if any, that would not be dischargeable or would not be discharged. Now, there's things that should be said about mortgages and car loans. In the Chapter 7, we're going to list the mortgage, we're going to list the car loans, and those get discharged along with all the other debts unless you sign a reaffirmation agreement during the pendency of the bankruptcy, and that thing has to be filed with the court. So the car loans and the mortgages get discharged. By the way, I'm really against reaffirmation agreements. They have their own problems. I should do a separate video on that sometime. Most of the time with a car loan or a mortgage, first mortgage or second mortgage, doesn't make any difference. My advice to my client is if you want to keep the car or if you want to keep the house, you keep making the payments. We shouldn't do a reaffirmation, but you should keep making the payments. With the mortgages, I've never seen a problem. The mortgage companies seem to always just accept the payments. And with most of the car lenders, it's the same. With the car lenders, there are a few that insist on these reaffirmation agreements, but most of them, way more than half of them, will just let you do what we call retain and pay. We have the term, retain and pay is kind of the term that we use for when we are talking about you're not going to reaffirm the debt, but you're going to keep the security like the car or the house, and you're going to keep making the payments. So for the typical Chapter 7 case, from the time you walk in my office to the time we get the discharge tends to be 5 or 6 months, because it takes me several weeks to put it together, and then once we file, it's about 3 months to the discharge. Typically, if there aren't any assets, within a couple weeks after that discharge, the clerk of court's going to close the court file, and that's that. I always like to see those court files close. I always kind of wonder, well, what can go wrong while the court file is still open? So I like to get into these things. I like to get out. And to quote Forrest Gump, that's all I have to say about that.